If you file a lawsuit, or if you're sued, what should you expect? I'm Dan Ringer, and we'll talk about lawsuits right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Many things that you should expect if you're involved in a lawsuit. Peace and happiness are not two of them. My guest is attorney Elliot Hicks. Elliot, welcome back.
Well, thank you, Dan.
We're going to talk about lawsuits, and,
Yep.
and that primarily because you're what we call a trial lawyer.
Yeah, and I know something about those.
I read your biography, your brief biographical sketch, and you've tried over 100 cases.
Somewhere thereabouts.
Probably more than that now because it's probably an old bio. Okay, I'm going to get involved in a lawsuit. I come to your office and I say, I want to sue them, or I've just been sued. What are you going to tell me?
Well, what a lawyer ought to tell you is that there's a long and arduous process that, as you say, I mean, it's not going to be a fun thing. It should be a matter of last resort. You really shouldn't do this as your first reaction.
Well, but I'm really upset about what these people did to me. And, frankly, I just want to get back at them.
But you're not as upset as you're going to be after you go through the process of suing and continue to build up all this bile and anger over the process and over what they did to you. So you compound that. You really ought to only sue over the most serious of matters. I think that, I know that there are some lawyers who are awfully litigious. In their personal lives, most lawyers are the least litigious people I know. In other words, they don't want to go and file a lawsuit in their personal lives for things that they would file a lawsuit for other people, over for other people.
It's not an issue of money. I don't care about the money.
Right.
It's
That's
the
what people
principle
say.
of the thing.
Yeah, most people can't afford the kind of principle you need to have to go through a long lawsuit like that. What happens is, mechanically, here's what to expect. The first thing is, as I say, your lawyer needs to tell you that this is going to be a long process. Most cases, from the time they're filed to the time they get to court, if they get to court, will take about a year and a half. You have to decide whether you want to relive this thing over and over for a year and a half, whether you want to have this kind of a disruption in your system. Most of us have our lives pretty well compartmentalized. We know what we're going to do. We know how long it's going to take. We know what our week is going to look like. This is something that's added to that. You've got to add in some time to talk to your lawyer. You've got to add in some time to possibly deal with discovery and talk with your lawyer's paralegal, to talk to the other side, to explain your case to the other side in what they call discovery. And discovery is really the thing that draws a lawsuit out. Discovery is. Oh, I'm sorry.
Yeah, let's pause for just a moment.
Sure.
Because you're talking about make time to talk to your lawyer. And I frequently see people who will say, I want to file this lawsuit, I want to challenge this action, whatever it is. And you say, okay, can you come in at 2 o'clock on Thursday? And the answer is, no, I have to work. Right. Well, when can you come in? Well, I really can't come in during the day or during the business week. That doesn't work very well.
It doesn't work very well at all. You've got to make time for it, and it's going to take more time than you think. I often serve as a mediator. Most of the cases.
Describe what that is.
Okay, but in most of the cases I usually handle for people who get sued. There are lawyers who specialize in filing lawsuits. Early in my practice, I did that.
It's called being a plaintiff's lawyer.
That's a plaintiff's lawyer, as opposed to a defense lawyer, which is what I primarily do at this stage in my career. But often now, at this stage in my career, a growing part of my practice is serving as a mediator, which, as the word implies, is a person who sits in the middle and tries to help the people on the two sides bridge their differences and work out some kind of a resolution. One of the things we always say is that the practice of law is still a practice, and we don't know what's going to happen. We can't tell you exactly what's going to happen when you file a lawsuit.
I hate having to tell people that.
Well, but it's the truth. I mean, what it is what it is. It's the truth. We don't know what when we file a lawsuit, we're throwing ourselves at the mercy of a judge who, we really don't know what he or she will do. We don't know how they're going to rule on certain legal issues. They may see the legal issues completely differently from the way we see them.
A client of mine once gave me a paperweight on the top of which is imprinted, "A good lawyer knows the law, a great lawyer knows the judge." And there's more to that than whoever inscribed that on the top of the paperweight knew.
That's true.
Because it really is beneficial if your lawyer knows what that judge's practice is, how they make decisions, what kind of things they look for, because it can save a lot of time, effort, and sweat for both of you.
Right. And it's not, and some can take that the wrong way and say that you know the judge as if he's your buddy or something. Well,
And I'm
no,
sure
not
that's
it.
what was intended when
Well,
that thing was
but that's
written.
not really it. I mean, the fact is, a good lawyer will know the judge, and what that should mean is, will know the tendencies of the judge, and will know something about how they look at the law. Then, in addition to the variable of the judge, you've got 6 people who will sit on a jury, 6 people you don't know who will sit on a jury.
I thought you had 12 people on a jury.
Well, in a criminal trial, you have 12 people, but we've tried to save some money in our civil system and reduce the number of people on the jury to 6, and so that's what we usually have now. One of the jokes I always tell, but again, it's truth spoken in jest, is that the event lines that you see in the paper with the great wisdom that you see in those, those are the people. I need to learn to speak to those people, and I read those.
You're talking about the reader's comments
Right,
and
reader's
the letters
comments.
to the editor, the comments online.
Well, worse yet, the ones that aren't signed. The ones that are signed, at least
Well, I'd
people are
never
willing
put
to
my name on
stand
those
behind, stand behind those. But the ones that aren't signed, those can be pretty crazy. And what I tell clients is, I've got to learn to speak to those people there, those people who have those wide-ranging ideas. I've got to learn to speak to those, because those are the people who are going to sit on your jury. If you trust the comments that you see there, if you trust the wisdom of that, then you're a person who can trust the jury system. If not, then you need to watch out.
I practice a fair amount of federal criminal law. Why anybody would do that voluntarily, I don't know, but I do a lot of that. And I often have, I hate to attach labels, but I will have a Chicago or a Los Angeles gangbanger involved in the federal criminal system. And I'm trying to explain to them why, if they're going to Wheeling, West Virginia, or Martinsburg, or Clarksburg, or Elkins, West Virginia, they might want to consider that the jury's not going to be sympathetic to them or understand them.
That's right. That's right. And so, because they have those variables in the court, I mean, the judge may see the law differently from the way I see the law. I'll explain it to him the way I see it, but the judge may see it differently. And then you've got these 6 people who are going to come in and look at it completely differently. So mediation has sprung up as a way to try to let people bridge their differences before that. And as a mediator, I often see people on both sides who are not prepared for the process.
We're talking about what you should expect if you get involved in a lawsuit. My guest is attorney Elliot Hicks. I'm Dan Ringer, and this is The Law Works. Well, how does the mediation process work? You're in the middle, so what do you do?
And the mediation process is, we try to bring people together at some time before everybody has spent a lot of money. Sometimes that's not possible because the discovery process, as I say, the discovery means that everybody has a right to find out what the other side is going to say and to commit that to writing by asking questions.
We'll talk about the technicalities here in a few minutes.
Okay.
Let's go ahead with mediation.
But and so we try to bring that as quickly as possible before people have spent a lot of money, and bring the people together face to face to try to talk about their differences with me as the mediator in the middle, so that they can try to see if they can iron it out and not face those variables that I described a moment ago.
Well, the process itself, you sort of float back and forth between the parties. I don't like you, Elliot. I don't want to see you face to face. but you need to hear what I have to say.
Well, that's right. And what it does, it gives you an opportunity. Sometimes people just want to be heard. And they'll file a lawsuit for that reason, because they just want to know that the other person heard and understood what they had to say. And for that reason, the process of mediation can be cathartic. Sometimes people need to do that long before they file a lawsuit. Sometimes people aren't ready to do that before they file a lawsuit. But we bring the people together to try to, first of all, talk and establish an air of civility. Then we usually separate them and let the mediator kind of carry messages back and forth to try to bridge the interests of the parties so that they can resolve their differences without facing those variables.
If I look at you, I may think you're a belly-crawling, scum-sucking, slime-swallowing, nasty person.
You might very well.
But if I can talk to someone else to carry the message to you, they may omit the colorful language.
That's exactly it.
And just say, this is what needs to happen.
That's right.
Yeah,
that's part of the catharsis too. They at least get to talk to somebody, even when they talk to the other person. That's good, but they can talk to somebody who's heard and understood them, and it may make the whole thing ease tension so that they can.
I've always felt that the major cause of lawsuits is the inability for the parties to communicate with each other.
That's right, and we're doing worse now since we're not used to speaking to each other. We become more and more detached because we text each other, we talk to each other through such indirect means that we're probably worse at that now than we were before.
Well, and you hear made-up figures all the time, and somebody may believe them. I think they're made up. It says somewhere between 85 and 95% of all communication is nonverbal. That means if I can sit and see you and talk to you, I can convey much more than if I just write 120 characters or something like that, or write an email. So a mediator kind of is a happy meeting place between those two extremes,
That's
no
exactly
communication and face-to-face communication.
That's right. That's right.
Well, and that allows.
So, one of the points I wanted to make was that what I see from both sides is that sometimes the lawyers have a tough time preparing their clients for the difficulty that is a lawsuit. Sometimes plaintiffs, people who want to sue somebody, will not be ready for the intrusion into their personal lives that a lawsuit is. They aren't going to be. They don't know that they have to answer questions about their medical condition. They say that it's caused them mental distress. Well, now that may mean that the other side gets to ask them about all the other things that have caused them mental distress. Well, what about your situation with your spouse? What about that child who's gone and gotten something pierced that you didn't want to have pierced? What about those things? Have those caused you stress? What about your job? What about the fact that you were disciplined at your job? Did that not cause you stress too? So why are you blaming me?
How old were you when you first started dating?
Those kinds
What's
of
the
things.
history of that? You're telling
exactly
me that my client abused you, that you've suffered emotional harm. Who else has threatened you with emotional harm?
And
How did you react to
And
that?
if the person on the other side runs a corporation or has a small business, you get to see a lot of figures and things from the corporation that really, they really didn't intend for you to see. You get to learn about inner workings of that business, the family business that might expose some raw nerves that you didn't want to have exposed. So a lawsuit is a very difficult thing, and I often, as a mediator, encounter people on both sides of the table who are not ready for the intrusive process of a lawsuit. Yet they have filed the lawsuit and they've started this snowball rolling.
And that's where discovery comes in.
Exactly.
This flow of information. There are various forms of discovery.
You can write questions down and ask the other side to answer those. Those are called interrogatories. You can also confront the person across the table and ask questions with a court reporter present who takes down every word that's said. That's called a deposition. So we have those things, and as I say, sometimes the questions are asked that are very uncomfortable for the people involved, and I see in mediations and in other, and for that matter, when I'm on one side or the other, I see people who aren't necessarily prepared for that, who aren't ready for the difficulty of a lawsuit.
And not the least of the concerns involved in that is that preparing written questions and preparing to conduct a deposition take your attorney a lot of time.
Right.
And once you get the results of the interrogatories and the depositions, it can take 3 or 4 times as much time to understand what those responses are, to index them, to extract them. I purchased a software program some time back that promises me insight into everything involved in the lawsuit. All I have to do is sit down or have someone type in each and every fact, the source of the fact, the document that demonstrates the fact, and then it will print out all kinds of things for me. That takes forever.
Exactly. Exactly.
And nowhere is the phrase "time is money" more true than in a lawyer's office.
That's absolutely true. My bitter joke is that I live my life in tenth of an hour increments, and so most of the time I get paid for every 6 minutes I spend in the office to do one thing or another, and that's the way I charge for my time. Some lawyers charge by what they call a contingent fee, where the lawyer takes a percentage of the money that's recovered. Oftentimes in plaintiffs' cases, they'll do that. People wonder, well, why in the world is the lawyer taking all the money? Well, if you want to have a contingent fee where you don't put out money in advance, where you don't pay for the lawyer's time in advance, that's a venture that the lawyer goes into with you, and that lawyer makes a bet, in essence, on the value of that case.
We're talking about what you should expect if you get involved in a lawsuit. My guest is attorney Elliot Hicks. I'm Dan Ringer, and this is The Law Works. I don't like contingent fees, but by the same token, that's the only way many, perhaps most people who have been injured or who have suffered a loss of some sort can afford to get in a courtroom.
That's right. That's right.
But it is rife with problems.
It is.
First of all, the attorney not only wants to be paid, typically needs to be paid. No one can spend hundreds of hours on a project without expecting to be paid for it at some point in time.
And despite the pristine ethical rules that we've lived under as lawyers, that tries to gain separation between what the lawyer does, the lawyer's interest in the case, and the client's interest, it makes the lawyer a joint venturer in the case with his or her client, which it has its own problems.
Well, yes, because the lawyer desires to be paid. If you come to a point in the case where the other side has offered you a sum of money, the lawyer looks at that and says, well, if we accept that now, I will do okay. Or I might do very well, depending upon what some of the money is, or I might lose money. And then the client says to the lawyer, is this a good offer? And the lawyer's sitting there thinking, boy, I got car payments and house payments coming up, and that puts him in conflict with the client.
Right, not only that, but the lawyer's experience may be that, look, let's take this now, because if we go further to trial, we have all those variables that we talked about. I have a former partner and mentor who said that when he sees these people go into court confident that everything is going to work out, that everything is going to work out the way the person thinks it'll work out, that person is a fool, because there's so many variables they can't know whether it'll work out. So the lawyer may look at the end result and say, look, if we have to go to trial, this may not work out, and we may get nothing. So I think you ought to take it now, where the client says, hey, I told you I'm in this on principle. And I want to pursue this to the very end. I want a verdict. I want the public to know that this other side was wrong, that what they did to me, they can't do to other people. So I want to proceed, even though the lawyer may, through his or her experience, say, we ought not to carry it any further. This is what we need to do. We need to settle.
Well, and sometimes you'll find the client who says, cost is no object. There's an old pizza story that whenever a customer comes into a pizza parlor, the clerk will say, what do you want on your pizza? And sometimes they will say, everything. The next word is always except. And it may be anchovies, it may be some sort of fungus, it could be all kinds of things they don't want on that pizza, but it's always an except. And clients are like that too. I don't care what it costs. Well, okay, it's going to cost you the largest sum of money you can imagine. No, that's too much. Except that sum of money.
Exactly.
And oftentimes, when you're involved in a lawsuit, you're suing an entity that really doesn't need to worry about the cost of the lawsuit. They may be out to make a point of the whole thing. Large corporations will sometimes do that, as will small businesses. Sometimes they feel like they're being picked on, and they're going to, as in the movie The Godfather, they said, they're going to go to the mattresses.
That's right.
They're going to fight with everything they've got.
Right. I mean, a small business that has a project, has a product that it makes, has pride in its product, has pride in its reputation in the community, and has no interest in having that reputation dragged down by making some kind of a settlement with somebody. They don't want the word to get out that they made some kind of settlement because they believe that's an admission that the product they made is bad or is wrong, and they just won't do it. So they'll try to carry this thing on to the very end, even though the tar pit that the plaintiff has walked into, may make it better that the plaintiff get rid of the case and settle.
At one time in our history, there was a thought by most major corporations that if they could extinguish lawsuits in the inception, they would be much better off. And aside from maybe producing better products or providing better services, which would do that, their position was, we'll just settle all these lawsuits. Right. And 30 or 40 years ago, if you sued a major international corporation and you said, I want $5,000 or $10,000, they may have just paid up and given you that to avoid the hassle. Right. That doesn't happen too much anymore.
No, it doesn't happen too much anymore. Certainly there are a couple of models, and I've certainly worked for clients who've had both. I've worked for clients who said, cost be damned, we're going to go ahead and defend our practices, defend our product to the end. And then I've had others who will go ahead and pay, even though I've worked up a full head of steam after learning the case and learn that the client didn't do anything wrong. And I think they ought to fight, but I always have to remember, it's not my money. It's not my money. And so the client has to make the determination of what they want to do and how far they want to carry it.
What's the best thing that a client can do in that relationship with the lawyer then to make sure that their best interests are protected and that things work out, if not reasonably, at least fairly?
Well, you have to be open with your lawyer. The last thing you want to do, you never, never, never want to have any secrets from your lawyer on the issues that become relevant to the case. Because if the lawyer the lawyer builds a great deal of strategy based upon the truth that you tell the lawyer, and if you don't tell the truth, it will come back to bite you. It will come back to bite you. It will become a problem. So you have to you have to be honest. You have to tell the truth. And sometimes, as I say, that truth causes one to dig below the ground that somebody was ready to expose. And I think that's the most important thing, is the truth that you tell your lawyer.
And the problem with that is you, as the client, may very well not know what the truth is. You may think you're telling the truth. I oftentimes tell people I only believe about 80% of what anybody tells me because of the source of it.
Right.
I may see you sitting at this table and walk into the next room and somebody says, what did you see while Elliot was sitting at the table?
Sure.
What color tie did he have on? What color shirt? Was he wearing a sports jacket or a suit? Right. I'm going to miss some of that.
Well, that's exactly right. I've got a story of my own. Somebody ran into the back of me when I was stopped at a light one time. And as we were getting out to try to exchange information, somebody came back clear around the block to say that they saw the yellow truck, saw the blue car run into the yellow truck. Well, I was in the blue car. I was in front. They couldn't have been right. Eyewitness testimony is not as reliable as people seem to think it is.
Many books have been written about that.
Right. That's exactly right.
Have you ever been surprised with what an otherwise bright, intelligent, objective jury does?
I'm always surprised by what a jury does. Some of the things that they consider are amazing. One of the best lessons we get in law school is in the court competitions that we have, where we kind of make up a court situation, and then we have students come up and play jurors. And in those, we get to have a camera in the jury room to deliberate. I was able to recreate that in a situation where I represented a client in Atlanta, where I was able to go and do this on a grown-up level. And when you have the camera in there listening to the jury's deliberations, it's amazing to hear what they consider. It's amazing to hear some of the things that you think are complete nonsense, things that you think have no relevance whatsoever. And nonetheless, that becomes the linchpin of their decision. So again, that should give no reassurance to a person who has a case before a jury that things are going to work out the way they should. Juries certainly bring the common sense, the common wisdom of the community into the room. Do you trust that common wisdom? Well, that's open to question.
It is better to be in control of your own destiny than to serve it up to someone who doesn't know you. Elliot Hicks, thanks so much for being with us. Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you have a legal problem and want to know if you need a lawyer, you can discuss your problem with a lawyer by calling 1-800-642-3617 Tuesday evenings from 6 to 8 p.m. That's 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.